In the United States Court of Appeals for the 11th Circuit. James Fred Barfield, Plaintiff, Appellant, versus Kevin Rambosk, et.al., Defendants, Appellees. Appeal from the United States District Court for the Middle District of Florida. December 29, 2015. Before Martin, Jordan, and Anderson, Circuit Judges. Per curiam. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 1 of 9. 2. James Fred Barfield appeals the District Court's grant of summary judgment, based on qualified immunity, in favor of the police officers he sued for false arrest, excessive force, and negligent infliction of emotional distress. After review of the parties' briefs and the record, we affirm. I. On July 29, 2011, Mr. Barfield was arrested for violations of Florida law arising from a suspicious vehicle investigation by the Collier County Sheriff's Department. In his action under 42 U.S.C. 1983, Mr. Barfield alleged that he was seized, detained, and arrested without a warrant and without probable cause, and that Deputies DiPaolo, Chapman, Kasey, and Wingo used excessive and unnecessary force in effecting his arrest in violation of the Fourth Amendment. He also asserted a state law claim for negligent infliction of emotional distress. The facts, viewed in the light most favorable to Mr. Barfield, are as follows. On the morning in question, Mr. Barfield, a large man about 70 years of age, was driving to Naples. He did not feel well, but kept driving. When he started to feel worse, he got off the highway and pulled into Freedom Square Plaza to get something to drink. He recalls trying to exit his car, but was unable to stand up and remained in his car with the engine running. That evening, around 9 p.m., Ms. Sherry Deckard, a manager at the Dollar Tree store in Freedom Square Plaza, called the Collier County Sheriff's Department to report that a man inside a case, 15 to 12,263. Date filed, December 29, 2015. Page, 2 of 9. 3. Running vehicle with lights on had been parked in the parking lot for the previous 3 hours. As a result, Deputy DiPaolo was dispatched to the scene to examine the suspicious vehicle. For his safety, Deputy DiPaolo shut off his lights and approached Mr. Barfield's parked and running car. Deputy DiPaolo asked Mr. Barfield why he was there, but Mr. Barfield did not answer. Deputy DiPaolo observed Mr. Barfield attempt to place his big thermos in a small cup holder and sway his body back and forth, indicators that Mr. Barfield may have been under the influence of alcohol or a controlled substance. Deputy DiPaolo then asked Mr. Barfield to exit the vehicle to further investigate the situation. Mr. Barfield complied, but with some difficulty. As he exited the vehicle, Mr. Barfield had to use the door frame to maintain his balance, and Deputy DiPaolo had to reach out to him at least twice to prevent him from falling. Deputy DiPaolo asked Mr. Barfield whether he had any medical issues or whether he had been drinking, and Mr. Barfield answered, no. At that point, Deputy DiPaolo decided to handcuff Mr. Barfield for their safety, in case Mr. Barfield tried to reach for a weapon or get behind the wheel and drive in his condition. Deputy DiPaolo ordered Mr. Barfield to give him his hands to be cuffed, and Mr. Barfield tensed up and pulled his body against his car, holding onto the door. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 3 of 9. 4. Frame, which prevented Deputy DiPaolo from handcuffing him. Deputy DiPaolo then asked Mr. Barfield to get on the ground, because he was not complying with the handcuffing command. Mr. Barfield refused and attempted to get back into his vehicle. As a result, Deputy DiPaolo tossed Mr. Barfield, causing him to fall to the ground. Deputy DiPaolo placed Mr. Barfield under arrest because he had resisted, refused to comply with the order to get on the ground, and attempted to get back in the car. Corporal Chapman then arrived as the first backup officer. Deputy DiPaolo asked for Corporal Chapman's help to get Mr. Barfield on his feet to be handcuffed. As soon as Mr. Barfield was on his feet, he reached inside his car, grabbed the steering wheel, and managed to get back inside. Corporal Chapman and Deputy DiPaolo pulled Mr. Barfield away from his vehicle and attempted to place his hands behind his back. Mr. Barfield continued to pull away, bracing and tensing his arms under his body, and reaching toward his waistband while kicking his feet, trying to get off the ground. Corporal Chapman explained that he feared that the movement toward the waistband might have been Mr. Barfield reaching for a weapon, and so the two officers tossed Mr. Barfield again. He was tossed a total of 3 times in a span of 28 seconds. At this point, Corporals Kasey and Wingo arrived and found Corporal Chapman and Deputy DiPaolo fighting with Mr. Barfield on the ground. After Case 15 to 12,263 date filed, December 29, 2015 page 4 of 9. 5. Giving Mr. Barfield several direct orders to stop resisting, Corporal Kasey tossed Mr. Barfield. Corporal Chapman then applied one handcuff. Because the taser had been ineffective, Corporal Chapman struck Mr. Barfield 5 times in the upper shoulder area, a pain compliance technique. That effort proved ineffective, and Mr. Barfield continued to grab onto his pants. Corporal Chapman tried to pry Mr. Barfield's fingers from his pants while Deputy DiPaolo simultaneously applied pepper spray to Mr. Barfield's facial area. Corporal Chapman was finally able to apply the second handcuff. Collier County EMS arrived shortly thereafter and transported Mr. Barfield to the hospital. Mr. Barfield arrived at the hospital with a closed head injury as well as contusions to his face, elbows, knees and feet. Mr. Barfield remembers nothing of these interactions with law enforcement. On appeal, Mr. Barfield argues that the district court erred in granting summary judgment based on qualified immunity for his 3 claims against the officers. 2. We review de novo the district court's disposition of a summary judgment motion regarding qualified immunity. See Duryu v. Pastor, 351 F.3d 1080, 1084, 11th Sir 2003. A motion for summary judgment should be granted when there is no issue as to any material fact that the moving party is entitled to a case, 15 to 12,263 date filed, December 29, 2015 page 5 of 9. 6. Judgment as a matter of law. See Federal R. Civ. P. 56, c. We resolve all issues of material fact in favor of the plaintiff, and then determine the legal question of whether any defendant is entitled to qualified immunity under that version of the facts. See Lee v. Ferraro, 284 F.3d 1188, 1190, 11th Sir 2002. A government official who is sued under 42 U.S.C. 1983 can seek summary judgment on the ground that he is entitled to qualified immunity. See Hallman ex Rel Hallman v. Harland, 370 F.3d 1252, 1263, 11th Sir 2004. To decide whether a defendant is entitled to qualified immunity, we engage in a 2-part inquiry. The defendant must first establish that he acted within the scope of his discretionary authority when the allegedly wrongful acts occurred. If he did, the burden shifts to the plaintiff to demonstrate that the defendant violated a constitutional right that was clearly established at the time. See Saucier v. Katz, 533 U.S. 194, 201, 2001. To determine whether a right was clearly established, we look to binding decisions of the Supreme Court of the United States, the 11th Circuit, and the Florida Supreme Court. See McLeish v. Nugent, 483 F.3d 1231, 1237, 11th Sir 2007. Based on these decisions, we ask whether it would be clear to a reasonable officer that his conduct was unlawful in the situation he confronted. Saucier, 533 U.S. at 202. The district court ruled that Deputy DiPaolo was entitled to summary judgment on Mr. Barfield's 1983 claim against him for false arrest. Mr. Barfield. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 6 of 9. 7. Argues on appeal that Deputy DiPaolo violated his Fourth Amendment rights by seizing him without reasonable suspicion and arresting him without probable cause. In a 1983 context, however, a police officer may be entitled to qualified immunity for an arrest even without actual probable cause as long as arguable probable cause was present. See Duruthy, 351 F.3d at 1089. Whether arguable probable cause was present depends on the particular elements of the suspected offense. See Crosby v. Monroe County, 394 F.3d 1328, 1333, 11th Sir 2004. Here, Mr. Barfield was arrested for resisting without violence in violation of Florida Statute 843.02 and resisting with violence in violation of Florida Statute 843.01. When Mr. Barfield refused to place his hands behind his back and tried to get back in his car, Deputy DiPaolo had at least arguable probable cause to arrest him. Significantly, and unfortunately, Mr. Barfield never communicated his medical problem to Deputy DiPaolo. Therefore, the district court did not err in concluding that there was at least arguable probable cause in this case and granting summary judgment to Deputy DiPaolo on the claim of false arrest. Mr. Barfield also contends that the district court erred in granting summary judgment to Deputy DiPaolo on the excessive force claim. To resolve whether an officer's use of force was reasonable given the circumstances, a court examines, 1. The need for the application of force, 2. The relationship between the need and amount of force used, and 3. The extent of the injury inflicted. See Draper v. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 7 of 9. 8. Reynolds, 369 F.3d 1270, 1277, 78, 11th Sir 2004, citations omitted. Mr. Barfield appeared to be under the influence of alcohol or a controlled substance and was actively resisting the efforts to handcuff him. We have held that non-compliance or continued physical resistance to arrest justifies the use of force. See Draper, 369 F.3d at 1278, holding that use of a taser to effectuate an arrest did not constitute excessive force when the suspect repeatedly refused to comply with the officer's verbal commands. Therefore, the district court correctly ruled that Deputy DiPaolo's use of a taser to control and handcuff Mr. Barfield did not amount to excessive force in violation of the Fourth Amendment. We also concluded that the district court correctly granted summary judgment on Mr. Barfield's claims of excessive force against the other officers, Corporal Chapman, Corporal Kasey, and Corporal Wingo. The force they used against a non-compliant suspect who was resisting arrest and disobeying commands, several uses of the taser and 5 blows to the upper body, were not excessive under the circumstances. See Mann v. Taser International, Inc., 588 F.3d 1291, 1306, 11th Sir 2009, concluding that the tossing of a woman 3 times, which led to her eventual death, did not amount to excessive force where the plaintiff actively resisted the deputy's efforts at a lawful arrest. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 8 of 9. 9. 3. Mr. Barfield sued for negligent infliction of emotional distress under Florida law, but he failed to demonstrate that the physical impact he suffered was caused by the officer's negligent conduct. Indeed, Mr. Barfield conceded in district court that his claim was improperly pled. See to 62 at 32. Therefore, the district court did not err in granting summary judgment on Mr. Barfield's claim for negligent infliction of emotional distress. 4. We affirm the district court's grant of summary judgment in favor of the officers on Mr. Barfield's 1983 claims and his state law claim for negligent infliction of emotional distress. Affirmed. Case, 15 to 12,263. Date filed, December 29, 2015. Page, 9 of 9.
Robert, here's the thing. Do you work in here?
I am working for Randy, thank you.
Okay, do you work inside this place?
Yeah, for today.
Is there anybody that can confirm that? Because you're coming out of a closed place. That's what the problem is.
Listen, he just let me out.
Okay, is he back there?
Yeah, he's still back there with the generator running.
Relax, okay? I have a job I have to do. You understand that? Okay, there's burglaries in these things all the time. I see you come out with a bicycle with a backpack, okay, at 9:30 at night.
I always wear a backpack, sir. You always know this.
Okay, and did I know you before I pulled you over? No. Okay, you're being very abrasive right now. What makes me think that you were back there doing something wrong? Do you understand that?
I would like to have a supervisor.
Well, too bad. That's not going to happen.
Are you denying my
Yes,
right?
I am, because you don't have a right to a supervisor. If you call 911, I am going to take you to jail for abuse of 911.
Why? Because you are not...
Because you're not, it's not an emergency.
I have the right to talk to your superiors.
No, you don't.
Yes, I do.
No, you don't. Did you get his ID yet?
It's Robert Price, I think is his last name.
No,
Robert
it's
something.
not.
Let me see your ID.
Just talk to 2008.
I don't give a shit about 2008. Let me see your ID.
I'm going...
He was coming out of here.
You
Everything's
know,
closed.
You guys are harassing me. You know...
Let me see your ID, man.
I have no ID.
Which storage unit is this guy in?
Why don't you just go write it down? You know Rock and Roll Randy.
What about him?
That's who I'm working for, thank you.
He owns a place back there? Because last time I checked, he was homeless.
What's your name, man? Robert. Robert what? Robert what?
On the phone, I'm getting my boss out. Thank you.
Corporal.
Hey, Randy, come out to the gate and talk to these officers, please. Thank you.
What's your last name, Robert?
Of the family in Harris. And I do not consent.
Harris? H-A-R-R-I-S?
If you want.
Sir, you do realize I have a valid reason to get your ID. You failing to produce your ID, we'll land you in jail. Do you understand that? Or if you fail to identify yourself.
I just don't like being harassed.
I'm
That's
not
all.
being harassed. I'm trying to get your name and date
No.
of birth, man.
Over there you have harassed me.
Look, what is your name?
Have I committed a crime, sir?
I am
Determine that.
I am investigating a loitering and prowling complaint, yes.
From who? I have the right to face my accuser, sir.
Well, you're
Are you
facing
taking
him.
your wages under false pretenses, sir?
Step off the bike. Step
Sir,
off,
do
step
not
off the
touch-
bike. Step
I
off.
don't consent! Ow! I have not done nothing!
Roll over.
I have not done nothing!
Turn around. Turn around.
I have not done nothing!
I'm gonna stick this man. Turn
I
around.
do not consent!
Turn around. Turn around.
I want your supervisor!
Watch out.
Get it.
Roll over now! Do it now! I'm going to tase you! Roll over!
Do it.
Watch me!
Do roll over.
Harass me! I have not done nothing!
Tase him again, boy. Go. He's kicking me.
I didn't... Oh!
Turn over.
I can't! He's fucking hurting me!
Dude, what are you doing? Turn over.
I can't, dude! You're on me! I will turn over if you... I have not done nothing! I have not done nothing!
Roll over!
I can't!
Roll over!
I want you supervised!
Turn over.
I want you supervised! I have not done nothing! I want your supervised!
I'm gonna tase you again. Better roll over.
I can't! He's on me, dude!
No one's on you. Roll over.
Okay, okay! Let me take my fucking bag off!
Roll the fuck over!
I will! I have not done nothing! Harassment! Stalking! I want
Mason!
I want supervisor!
You're gonna get Mason, you don't roll over!
I have not done nothing, sir! Ah!
Dude, turn over. What's wrong with you?
I have not done nothing!
Stop fighting and just turn
I'm
over.
not fighting!
Grab me like that again.
I'm not grabbing you! I have not done nothing!
Turn over.
I can't! I can't fucking turn out, dude! I don't consent! You have violently
I wouldn't tase you again.
I can't fucking see, dude!
Roll over!
I can't see! Hold on! I can't fucking see, dude! You have violated my rights! I want to make your supervisor! Ah! You can't! I want your supervisor now!
Dude, don't grab me! Put your hand behind your back!
You think that fucking hurts?
Put your hand behind your back, man!
I did not do nothing!
I can't breathe. Okay, just hold it.
I did not do nothing, boss! I did not do nothing!
Alright, I got one. Dude, what's doing me?
Come here! I did not fucking do nothing!
Give me your arm! Give me your arm!
Watch out!
Give me your arm! Yeah! Give me your arm!
I can't move!
Stop fucking moving! You're gonna do it again!
I didn't even fucking do nothing!
Bring your head on your back!
Canine coming.
Coming. Taser deployed? No, yeah. Taser deployed. Taser deployed. Back there.
I didn't even fucking do nothing!
Yeah, go around this way. Go around this way.
I got fucking hurt! I can't fucking breathe!
Good.
I didn't even do nothing!
Hey, grab him. Grab him.
I can't fucking breathe! I didn't even
Dog! Give me that dog! Get out of the way!
I didn't even do
Get
nothing!
off his leg! Get off his leg! Dude, get off his leg! Watch out! Watch out! Get off! Whoa, wait.
I can't even fucking breathe! I can't breathe!
This gentleman right here.
Canine, step it up. Got K9 coming, K9 coming. Taser deployed? No, yes or no?
Taser deployed.
He's up.
He's back there.
I didn't even fucking do nothing.
Here, light him up again if you have to.
I got fucking hurt.
Okay.
I can't fucking breathe.
Yeah, he's good. He's good.
I didn't even do nothing.
Tappy. Hey, grab him. Grab him.
I can't fucking breathe.
Got K9 here if you need him. Keep fighting, man.
I didn't even touch.
Give me that dog. Get out of the way.
I didn't even do nothing.
Get off his leg. Get off his leg, Steve. Get off his leg. Watch out. Watch out. Get up.
Whoa, wait. He's coming at him.
I can't even fucking breathe.
Shut up.
I can't breathe.
What is this? Get the hold on.
This gentleman right here.
Oh, he's right along.
He needs to fit the car. Go fit the car, please.
Right along.
I didn't even do
Who's right
nothing.
along this end? He stays in the fucking car.
Yeah.
I didn't even
The
do
fuck? Who's
nothing.
is he? Whose is he?
Mine.
I didn't even do nothing. I want you to
Where's
I
Jeff?
can't
You
even
all right?
fucking breathe.
Somebody take care of him.
I can't even
What do we need
fucking
EMS for? Hey, we just got the one?
I guess so. I think so.
Just the one, Wingo? Yeah, just. Hey,
I didn't
Do you need an ambulance?
nothing.
He can't undo it. Get his vest off.
I can't breathe.
He can't breathe. Get his vest off.
Fucking do nothing.
My phone's charged, so I can't get
He said he can't breathe. Yeah. Roll over to your side. You're gonna roll to your side. Roll to your side.
He's probably,
Right there.
probably
That's fine. He can just sit on his side.
No, we're good. We're responding by guarantee.
I just can't ready for you. The shop is broken. It won't shut.
The,
Exit gate.
yeah, it's
Able can 11 clear, marker and Jason.
10 in the last you put out.
Clear 33 traffic.
I got 10-8, 10-33 traffic, 10-8, 10-33 traffic. Able 3 Charlie, 21, 10-13.
Cancel. Able to Marine 111.
Marine 111.
I know they're tied up. If you get any priority calls, go ahead and dispatch me out.
Bus 3 Charlie 20 on units on Tollgate 1015.
Everything cancel bus. Hey, what's your Charlie phone? You're calling on Tollgate. Answer. Try calling the other call.
Naples Marine 112, 1065 at 22 on Bravo Zone.
111.
10 Fords, 2740 Bayshore Drive, 2740 Bayshore Drive, cross the 41 at New Attitudes. Call advising there's a white male, signal 2, and starting trouble and wants to fight people. Just got out of detox and the last thing wearing a white sleeveless t-shirt and blue shorts. Negative signal 0.
Okay, 451. 3 Bravo 20, 861. Bravo 20, Bravo 861. Go ahead, sir. Can I have your last one, please? 4584, 4584. Roger.
Holding a signal 50 and Alpha Zone up, Hibiscus Avenue and Central Drive. Advising there's a bunch of black males and white females that live in the area selling signal 50 on bicycles. Call off to be anonymous, but want something done about it.
Alright, next build.